Hi there, how are you doing? In today's video, we are basically going to be looking at the structure of the judiciary in Uganda, and specifically we are going to be looking at the Supreme Court, the Court of Appeal, the Constitutional Court, the High Court, and the subordinate courts, which will include the Chief Magistrate Courts. We'll be looking at the composition of these courts and also the jurisdiction or the powers of these courts. Once again, ladies and gentlemen, my name is Mutiaba Conrad. I'm a lawyer and a private law tutor, and I encourage you, before we start on our class, to subscribe to my channel. Just below on your screen, there's a red button on the right lower hand corner. Just click on it. Also turn on your notifications so that every time videos are released, they are always brought to your attention. And also ensure that you share and like this video with your colleagues so that they can also benefit from this knowledge. But also, very importantly, for students who are interested in private law tutorial sessions, please ensure that you reach out to us. We'll be able to help you. We'll make private arrangements in your office, at school, or at home, and we'll be able to help you. Private tutorial sessions really work, and all students that are on our private tutorial programs have been proven to outperform their colleagues who do not have any sort of mentorship or help. Once again, the numbers are down in the description box. Just contact us. So ladies and gentlemen, let's dive directly into it. Let's start by looking at the Supreme Court. But however, before we even proceed to look at the Supreme Court and to lay down the complete structure of the judiciary in Uganda, it's very important to first lay down the legal framework or the supreme law that actually provides for these courts. I encourage you to look at Article 129 of the 1995 Constitution of the Republic of Uganda. And when you examine that article, it actually lays down the various courts and the whole structure. And it lays down the Supreme Court as being the highest court, followed by the Court of Appeal, and then followed by the High Court, and then all other subordinate courts. Specifically, look at Article 129, Clause 1 of that Constitution. And then also of interest, when you look at Article 129, Clause 2, it actually provides that the Supreme Court, the Court of Appeal, and the High Court will be courts of record. Okay, very, very important to note. Now, having laid down that legal framework under the Constitution, let's now proceed to look at the Supreme Court as the first court. Now, it's important to note that the Supreme Court is a superior court of record provided for under Article 130 of the Constitution, and it is the highest court of the land. Okay, so there is no any other court above the Supreme Court in Uganda. Then also of interest to you is Section 3 of the Judicature Act as amended of 2011. It states that the Supreme Court shall consist of the Chief Justice and 10 justices of the Supreme Court. Okay, very important to note. Let's now proceed and we look at the composition of the Supreme Court. I encourage you to look at Article 131, Clause 1 of the 1995 Constitution of the Republic of Uganda, which states that the Supreme Court shall be duly constituted if it consists of an even number, but not less than 5 members of the court. Very, very important to note. So it cannot have less than 5 members. Also of interest to you is Article 131, Clause 2 of the same Constitution, which provides that when hearing appeals from the Constitutional Court, the Supreme Court shall consist of a full bench of 7 justices, and where one cannot attend, the President shall appoint a replacement for that purpose. That is where one cannot attend, maybe for health reason or for any other a strong reason. Also of interest is Article 131, Clause 3, which provides that the Chief Justice shall preside over at every sitting, and in his absence, the most senior member. Okay, most senior member. Then let's now proceed to look at the jurisdiction of the Supreme Court. And for purposes of jurisdiction, I encourage you to look at Article 132 of the Constitution. And it provides that the Supreme Court has appellant jurisdiction from the Court of Appeal and also from the Constitutional Court. And it's the final Court of Appeal. So when you appeal from the Constitutional Court or Court of Appeal, you to the Supreme Court, after it gives a judgment, you have no any other court where you can appeal in Uganda the decision of the Supreme Court of Uganda. Also of interest to you is Article 132, Clause 4, which states that while treating its own previous decisions, that is the Supreme Court, as binding, it may depart from its own previous decisions, and the courts are bound to follow its decisions. So basically, this brings in the doctrine of precedent, or the doctrine of stare decisis, which basically the article is stating that for decisions of the Supreme Court, when made by that same court, they are actually binding to the Court of Appeal, the High Court, and all Chief Magistrate Courts, meaning that they cannot deviate or go away from the decisions of the Supreme Court. Of course, this is if the facts are similar to the matter that such a lower court is handling, and of course also the exceptions to that principle where courts can actually divert from a decision of the Supreme Court, which, if you're interested, you can also look at my other video on my channel, which covers the doctrine of stare decisis and the doctrine of precedent, which actually looks at those exceptions. Let's now proceed. It's important to note that the Supreme Court actually has original jurisdiction in presidential election petitions. So in matters of presidential election petitions, in case one of the candidates is dissatisfied, it's only the Supreme Court that actually has original jurisdiction to hear such matters. And authority for that position can be found in the case of retired Dr. Kanokiza Besigye versus Yoweri Kaguta Museveni and others. That is election petition number 1 of 2001, where a court held that for presidential election petitions, it's only the Supreme Court that has original jurisdiction, and its decisions are final and they cannot be appealed to any other court. Of interest also, let's proceed to look at Section 8, Subsection 1 of the Judicature Act, which actually states that a single justice of the Supreme Court may exercise his power in an interlocutory cause. So it is very possible that a matter can actually be heard by a single justice of the Supreme Court. And also under Section 8, Subsection 2 of the same Act, which is the Judicature Act, any party who is dissatisfied with such a decision of the single judge of the Supreme Court may actually appeal such a decision before a bench of 3 justices of the Supreme Court. So in case you're appealing a decision of a single judge of the Supreme Court, which of course has been heard if it's an interlocutory cause, then you appeal it to a bench of 3 justices of the same Supreme Court. Very important to note there. Now, that's all really with the Supreme Court. Let's now proceed to look at the Court of Appeal. Article 134 establishes the Court of Appeal, and also of interest is Section 9 of the Judicature Act, which states that the Court of Appeal shall consist, 1, of the Deputy Chief Justice, who of course is the head of the Court of Appeal, and 14 justices of the appellant court. Then also of interest to you is Article 134, Clause 2, which provides that the Court of Appeal has appellant jurisdiction from the High Court, meaning that the Court of Appeal can hear appeals from the High Court. Let's now proceed to look at the composition of the Court of Appeal. I encourage you to look at Article 135, Clause 1, which provides that the Court of Appeal shall be duly constituted if it consists of an uneven number, but of not less than 3 members. So meaning that the minimum number that the Court of Appeal can have to hear matter is actually 3 members. Of interest also is Article 135, Clause 2, which provides that the Deputy Chief Justice shall preside over the Court of Appeal, and in his absence, the most senior member can preside over that court. Of interest to you also is Section 145, Subsection 3 of the Local Governments Act, Cap 243, which provides that the Court of Appeal has appellant jurisdiction from the High Court on parliamentary and local council election petitions, and its decisions shall be final. So for purposes of elections where a member of parliament or a local council leader disputes an election, they can appeal from the High Court to the Court of Appeal, and the Court of Appeal is the highest court for election petitions of members of parliament and local council elections. You cannot appeal them to the Supreme Court. That is the position of the law. Let's proceed now to look at Section 12, Subsection 1 of the Judicature Act, which provides that a single justice of the Court of Appeal may exercise power of the court in any interlocutory cause. So just as we saw under the Supreme Court, also for purposes of interlocutory causes, the Court of Appeal, a single justice can actually hear it. And under Section 12, Subsection 2, any person who is dissatisfied with that decision of a single judge in an interlocutory cause that is a single judge of the Court of Appeal, can actually appeal that decision before a bench of 3 justices of the same court. Let's now proceed to look at the Constitutional Court. And basically, the Constitutional Court is governed by Article 137, Clause 1 of the 1995 Constitution of the Republic of Uganda, which provides that any question as to the interpretation of the Constitution shall be determined by the Court of Appeal, sitting as the Constitutional Court. So for the Constitutional Court, it's important to note that it is the same Court of Appeal, but which simply constitutes itself into the Constitutional Court. Then also of interest to you is Article 137, Clause 2, which provides that the Constitutional Court shall consist of a bench of 5 members. So it has full quorum when it has 5 members. Let's now briefly proceed to look at the modes of reference to the Constitutional Court. How does a party reach the Constitutional Court? The first mode of how a party reaches the Constitutional Court is under Article 137, Clause 3, and that is where a person alleges that an act or law is inconsistent with the Constitution. That person may actually petition the Constitutional Court for a declaration to that effect, to the effect that such an act or law or either a law or an act of a person or any action is actually unconstitutional. Then also the other mode of actually commencing a suit before the Constitutional Court is under Article 137, Clause 5. And this is where any question as to the interpretation of the Constitution arises in any other court apart from the court-martial. Such a party can request the court, that is the lower court, either the High Court or the Chief Magistrate Court, to actually refer that question of constitutional interpretation to the Constitutional Court. Those are basically the 2 modes by which a matter may be referred to the Constitutional Court for constitutional interpretation. Let's now proceed to quickly look at the High Court of Uganda. Basically, the High Court of Uganda is established by Article 138 of the 1995 Constitution of Uganda. And also of interest to you is Section 13 of the Judicature Act, which provides that the High Court shall consist of the principal judge and 25 judges of the High Court. Okay. Also of interest to you, you can also look at the case of Uganda Revenue Authority versus Rubble Enterprises. It's a Supreme Court decision where basically a court held that the High Court has no original jurisdiction in matters of tax disputes. So if there is a tax dispute, the first court of instance is actually the Tax Appeals Tribunal, and where you're dissatisfied, you then appeal to the High Court. Then also of interest to note is that the High Court has jurisdiction in criminal matters. I encourage you to go and look or interest yourself in Section 48 of the Criminal Procedure Code Act. So I insist the High Court has revisionary jurisdiction in criminal matters. Then let's now proceed to look at the jurisdiction, which we have also partly looked at, but also as pertains further the jurisdiction of the High Court. It's important to note that the High Court also has what we call confirmatory jurisdiction of decisions of the Grade 1 and Grade 2, and authority for that position can be found under Section 173 of the Magistrate Courts Act of Uganda. Also, furthermore, on the aspect of jurisdiction, Article 139, Clause 1 of the 1995 Constitution of the Republic of Uganda provides that the High Court shall have unlimited original jurisdiction in all matters. So what we mean by original jurisdiction, here we mean that a matter or a case or a suit can actually be commenced directly from the High Court, and its jurisdiction is unlimited. It doesn't matter how much the value of the suit is, provided it's above 50 million, then that is good enough. Let's now proceed to look at Article 139, Clause 2, which provides that the decisions of the lower courts can be appealed to the High Court. So decisions from the Chief Magistrate Court, Magistrate Grade 1 and Grade 2, can be appealed to the High Court. Also of importance to note, as pertains jurisdiction, is that the High Court has jurisdiction in enforcement of human rights. So any issue pertaining to violation of human rights, the High Court has powers to enforce the same. Authority for that position, I encourage you to look at Rule 3, Sub-Rule 1 of the Judicature Fundamental Rights and Freedoms Enforcement Procedure Rules of 2008, and please read that together with Article 50 of the 1995 Constitution of the Republic of Uganda. Also of interest to you is Section 14, Subsection 2 of the Judicature Act, which provides that the jurisdiction of the High Court shall be exercised in conformity with written law and in as so far as applicable with common law and the doctrines of equity, and also the established custom and usage. So meaning that when the High Court is making decisions, it has to ensure that it follows common law, the doctrines of equity, the customs of the Ugandans, and also as far as applicable, those principles have to be applied. Also, furthermore, of interest to you is Section 17 of the Judicature Act, which provides that the High Court shall have supervisory jurisdictional powers over magistrate courts. So the position of the law is that all these magistrate courts are actually supervised by the High Court, and the High Court has power to supervise all their actions and their courses or their courses of action as well. Also of interest is Section 20, Subsection 2 of the Judicature Act, which provides that the High Court is duly constituted with one justice. So meaning that as long as there is one judge, the High Court can proceed to hear matter. However, it is also important to note that there are circumstances where the High Court can actually be composed of more than one judge. What are those circumstances? Those are actually the exceptions, and exception number 1 is appeals of advocates from the disciplinary committee of the Law Council. So when it is hearing appeals from the disciplinary committee of the Law Council, the High Court is actually composed of 3 judges. Then also the other exception is under Section 10 of the Labor Disputes and Arbitration Amendment Act of 2020, which provides that when the industrial court is actually sitting to hear matter, it will be composed of 5 judges. Okay, 5 judges. There are also other members that will sit on the panel, such as the representatives of the workers and the representative of the employers as well. But what is important to note is that in such a circumstance, the industrial court will have more than one judge. Those are basically the 2 exceptions to Section 20, Clause 2 of the Judicature Act, which provides that the High Court is fully composed where it has one judge. Also of interest to you is Section 38, Subsection 1, which provides that the High Court may, upon or on hearing judicial review, or where it hears matters pertaining to judicial review, it may grant any one of the following remedies, which include an order of mandamus, prohibition, certiorari, an injunction, or even a declaration. But also under Section 38, Subsection 2, it also has powers to award damages. Those are the powers that the High Court has. Let's now proceed to look at the magistrate courts generally. Okay. Now, magistrate courts are established by the Magistrate Courts Act Cap 16, and the magisterial area instruments define magisterial areas in Uganda. So what you have to note is that these chief magistrate courts are actually divided into various magisterial areas, and magistrate courts basically include the chief magistrate court, the magistrate grade 1, and also the magistrate grade 2. However, it's important to note that although the magistrate grade 2 are being eliminated, okay, magistrate grade 2 are being eliminated slowly, but however, these courts can only exercise territorial and geographical jurisdiction. Those are the chief magistrate courts. But whereas the magistrate grade 2 courts are actually being gradually eliminated from the judicial structure, or rather from the court structure of courts in Uganda, it's important to note that in some parts, and indeed so many parts of Uganda, these courts are actually still present. For example, as of 2022, there is the Goma Ntenjeru Grade 2 Court. It is still existent, okay, that is in Mukono. And in other parts, the Grade 2 are still existent, although they are still being gradually phased out. Now, these courts are actually established by law, and I encourage you to look at Article 129, Clause 1, D of the Constitution, which states that the judicial power of Uganda shall be exercised by courts of judicature, which shall include such subordinate courts as Parliament may by law establish. And such subordinate courts, for example, have been established by the Magistrate Courts Act. Let's now proceed to look at the Chief Magistrate Courts, and specifically the Chief Magistrate Court is provided for under Section 5 of the MCA, which states that a magistrate's court shall be duly constituted when presided over by one magistrate. So as long as there is one magistrate, then the court is ready to go and hear matter. Also of interest is that chief magistrates have to be holders of a degree in law and a postgraduate diploma in legal practice, and such a magistrate presiding over a chief magistrate court has to be a senior magistrate, having gained extremely good experience in practice or in law generally. Also of interest to you is the case, this pertains to the jurisdiction. We are now proceeding to look at the jurisdiction of this Chief Magistrate Court. And I encourage you to look at the case of Mlindo Emmanuel versus WBS TV, where a court held that Chief Magistrate Courts actually have jurisdiction in cases of workers' compensation and are within the exclusive jurisdiction of these courts. So in essence, the court was trying to hold that chief magistrate courts actually have powers to hear matters pertaining to workers' compensation. That is the first aspect of jurisdiction of these courts. Important to note is that a chief magistrate exercises original and appellant jurisdiction and hears both criminal and civil matters. Also important to note is under Section 161 of the Magistrate Courts Act, which provides that the Magistrates Court shall be presided over by a chief magistrate and may try an offense other than an offense whose maximum penalty is death. So chief magistrate courts cannot provide or cannot hear matters where the punishment is death, such as murder, rape, treason, among others. They do not have those powers. Such cases have to be sent to the High Court. Also of interest to you is that the chief magistrate hears appeals from a magistrate court grade 2 and the town division and sub-county local courts. Authority for that position, I encourage you to go and look at Section 32, Subsection 2C of the Local Council Courts Act, and also look at Section 220, Subsection 1B of the Magistrate Court of the MCA, which is the Magistrate Courts Act. It's also of interest. Let's now proceed to look at Section 3 of the MCA, which provides for the territorial jurisdiction of magistrate courts, and it states that there shall be established in such places in each magisterial area the magistrate's court where it has jurisdiction, meaning that for every magisterial area there is always a chief magistrate's court. Also of interest to you is Section 207, which provides that in respect to civil matters, the value of the subject matter should not exceed 50 million shillings and shall have unlimited jurisdiction in matters relating to conversion, damage to property, and trespass. So basically here what we are saying is that the Chief Magistrate Court can hear matters of a financial value of below 50 million. If it's above 50 million, then it cannot be heard by the Chief Magistrate Court. It has to be sent to the High Court. Now, important to note is that the Chief Magistrate has unlimited jurisdiction in the following matters, meaning that all the following matters that I'm going to talk about, the Chief Magistrate can hear them, no matter the value, whether they are worth 1 trillion shillings or 1 billion shillings. The Chief Magistrate Court actually has powers to hear such matters. Which matters are those? One, that is matters pertaining to conversion. 2, matters pertaining to trespass. 3, matters pertaining to damage to property. And civil matters, and the law for this, I encourage you to look at Section 207 of the MCA. And then lastly, it also has unlimited jurisdiction to hear civil matters exclusively governed by customary matters. Again, look at Section 207, subsection 2 of the MCA. It provides for that. Also important to note is where a charge has been brought against a person in a court with no jurisdiction to try the offense, the accused shall be remanded to appear before a court with jurisdiction. So in case a charge has been instituted before a magistrate court and the magistrate court does not have power to hear it, the magistrate court will remand such an accused person until he is referred to the High Court, which has jurisdiction. Also of interest to you is Section 221, Clause 1, which provides that the Chief Magistrate shall have general supervisory powers over all magistrate courts within his or her jurisdiction. So for these lower courts, such as Magistrate Grade 2 and 1, the Chief Magistrate Court has powers to supervise all their actions, and that is the position of the law. Let's now proceed to look at the Magistrate Court Grade 1. Basically, this court is presided over by a magistrate grade 1, who again is a holder of a degree in law. These are very qualified magistrates, and a postgraduate diploma in legal practice. Also, let's now proceed to look at the jurisdiction of this magistrate grade 1. The magistrate grade 1 hears both criminal and civil matters and exercises only original jurisdiction. Section 161 of the MCA provides that a grade 1 may try any offense other than an offense whose maximum penalty is death or life imprisonment. So magistrate grade 1 courts cannot hear offenses where a penalty is death or life imprisonment. Let's now proceed to look at section 162 subsection 1b of the MCA, which provides that a magistrate may pass a sentence for imprisonment not exceeding 10 years or a fine not exceeding 4.8 million shillings, or actually both. Important to note. That is for criminal purposes. Then let's now move on to look at section 207 subsection 1b, which provides that a grade 1 shall have jurisdiction where the value of the subject matter does not exceed 20 million shillings. Important to note. Then also under section 207 subsection 2, it provides that where the cause or matter of a civil nature is governed only by civil customary law, the jurisdiction of the chief magistrate and magistrate grade 1 shall be unlimited. So again, this magistrate grade 1 actually has unlimited jurisdiction in such matters. Let's now proceed to look at section 220 subsection 1a of the Civil Procedure Act, which actually provides that civil appeals from a grade 1 are to the High Court. This is very important to note. If you are appealing for if you are appealing from a magistrate grade 1, okay, you don't go to a chief magistrate. You actually go straight to the High Court. Very important to note. Also of interest is section 204 subsection 1a of the MCA, which provides that criminal appeals from a grade 1 are also to the High Court. Important to note. Let's now proceed to look at the Magistrate Court Grade 2. This court, originally, the Magistrate Court Grade 2, it's important to note, just to give you a brief history, originally these Magistrate Grade 2 were actually presided over by a holder of a diploma in law. Okay, very, very interesting, but that was many years ago. Today, most of these judges in these courts have actually upgraded and attained a degree of law and a postgraduate diploma in legal practice. But before, they were actually presided over by a diploma holder. Of course, in those days, lawyers were very few, people who were qualified were very few, and a qualification by having a diploma in law was sufficient. But today, we have moved on. Now, most of these are presided over by highly qualified lawyers with a degree in law, a postgraduate diploma, and even others have masters in law. Let's now proceed to look at the jurisdiction of this chief of this magistrate grade 2. A magistrate court grade 2 only exercises original jurisdiction. Only original jurisdiction is what this court exercises. Of interest to you is section 161 subsection 1c of the MCA, which provides that a magistrate grade 2 may try any offense other than offenses specified in the first schedule of the Magistrate Courts Act. So it can try very many offenses provided they are specified under the first schedule of the Act. So please go and look at that schedule so that you familiarize yourself with those offenses that can be tried, that cannot be tried by a magistrate grade 2. Also of interest to you is section 162 subsection 1c of the Magistrate Courts Act, which provides that a magistrate grade 2 may pass a sentence of imprisonment for a period not exceeding 3 years or a fine not exceeding 500,000 Ugandan shillings or both. So they cannot give a fine that exceeds 500,000 shillings or pass a punishment that is actually exceeding 3 years of imprisonment. Also of interest to you is section 207 subsection 1c of the MCA, which provides that a magistrate grade 2 shall have jurisdiction where the value of the subject matter does not exceed 500,000. So these courts do not hear matters where the value is above 500,000. The same would be, or such a matter would be referred to a higher court that has that pecuniary jurisdiction. Finally, let's look at section 204 subsection 1b of the Magistrate Courts Act, which provides that criminal appeals from grade 2 are to the chief magistrate. So criminal matters, provided they are coming from magistrate grade 2, they go directly to the chief magistrate court, and they don't actually go to a magistrate grade 1. So basically, ladies and gentlemen, that was all. It was very comprehensive. That is it on the structure of courts in Uganda. Once again, I encourage you to subscribe, like and share my channel, and also turn on your notifications so that every time videos are released, you're able to be in the know. And also, students encouraged interested in private law tutorial sessions, please feel free to reach out to us. Our numbers are down in the description box. Please contact us. Bye-bye. See you in another class.